So this is a plenary session 2, wherein we are going to be looking into these new issues in the competition law and policy, especially with regard to the digitalization of markets and with the advent of emerging technologies. This session invites once again a collaborative approach, a collaborative effort among the BRICS nations to foster a level playing field in the global marketplace, to encourage competition, to facilitate knowledge sharing, eliminate barriers which are imposed by the tech giants, promote fair trade, enhance consumer welfare, and ensure transparency in the digital markets. We are also going to be discussing in this how the antitrust authorities respond to these challenges, sharing lessons from the experiences. That's going to be very crucial as we navigate the evolving landscape of the digital market. That was also reflected when we had the plenary session, with this entire scenario changing with the new emerging technologies, with Industry 4.0, with the digitalization of markets. There are newer issues, new dimensions, new perspectives, new opportunities which are also emerging. And that is where once again we come together towards addressing these challenges, which encompass aspects such as digital market structures, the behavioral biases, data privacy concerns, also the outdated regulations. So we need to rethink on our traditional tools and traditional regulations which have been there, and then work on a more evolving public policy. So these are some of the discussion points which we are going to be taking with our speakers in this session. And for the first time, in fact, in this session, apart from the government representatives, we have the private sector representation also, for it is necessary to understand from the industry point of view also. And as we work towards building this more conducive and enabling environment, that is where an interface and understanding of the industry and the government needs to be also focused on. So I think our speakers are here. May I request people who are standing, kindly take your seats. Let's have the house in order as we begin this session. So I invite our moderator of the session, Mr. Hardin Ratchisusu, the Deputy Commissioner, CCSA, South Africa. Our distinguished speakers of the session, Ms. Shweta Kakkar, Member CCI, India, Mr. Victor Oliveira Fernandes, Commissioner CADE, Brazil, Mr. Maxim Shaskolsky, the Head of FAS, Russia, Ms. Genlin, the Honorable Vice Minister of SAMR and the Administrator of the State Anti-Monopoly Administration, China, Mr. Hari Prasad Govinda, the Principal Economist in the Economic Research Bureau, CCSA, South Africa, and Mr. Rajat Kathuria, Professor, Shiv Nadar University. So we have the government, the academia, the private sector. Before I hand over to our moderator for the session, I will just take this moment also to introduce our speakers. Some of the speakers were already part of the plenary session 1. So I will just taking permission from them that I will not be introducing them in the interest of time, but the others who have joined us, a quick introduction of all of them. We have our moderator, Mr. Hardin Ratchisusu, the Deputy Commissioner of the Competition Commission of South Africa. He is currently also the Adjunct Associate Professor with the Graduate School of Business Leadership of the University of South Africa. He's worked in the regulatory field with extensive experience in the competition regulatory environment, both in the public and the private sector, across industries like in communications, broadcasting, mining, chemicals, retailing, property, healthcare, and food. Our eminent speaker, Ms. Shweta Kakkar, she's a member CCI India. Ladies and gentlemen, she is the first member from the private sector to be part of the commission. As a lawyer, she has more than 2 decades of rich experience in dispute resolution, handling varied civil and corporate litigations for the Indian and the international clients in different fora. And she has dealt with cases before various tribunals like the National Company Law Tribunal, Company Law Appellate Tribunal, Consumer Disputes Redressal Commission, Debts Recovery Tribunal, CCI, and the others. We have Mr. Victor Oliveira Fernandes, Commissioner CADE Brazil. He was there in the plenary session, so I'm not introducing him in detail, but glad to have him here. Mr. Maxim Shaskolsky, the head of FAS Russia, and Ms. Ganlin, the Honorable Vice Minister of SAMR, and also the Administrator of the State Anti-Monopoly Administration, China. We have Mr. Hariprasad Govinda, the Principal Economist in the Economic Research Bureau at the Competition Commission of South Africa. Prior to joining the Commission, he was a research fellow at the CUTS Institute for Regulation and Competition, New Delhi, and also has served as an expert, economic matters expert at the Economic Division, Competition Commission of India, New Delhi. He is published widely on the competition law and economics in leading local and international journals and books, and has been also involved in a number of merger, cartels, and enforcement cases, apart from several projects. We have Mr. Rajat Kathuria, the Dean of the School of Humanities and Social Sciences and Professor Economics at the Shiv Nadar Institution. He is the former director and the chief executive of the Indian Council for Research on International Economic Relations. He's also worked with the TRAI, that's the Telecom Regulatory Authority of India. He's currently the co-chair of the T20 Digital Task Force under India's G20 presidency. He has more than 20 years of experience in teaching, 25 years of experience in economic policy, besides research interest on a range of issues relating to regulation and competition policy. So with that, I think Rajat is going to be joining us, but in case we start this session, and I request our moderator, sir, for the proceedings of the session. Thank you.
Thank you, Program Director. Good afternoon, delegates. It is indeed a pleasure to be in New Delhi for this 8th International Competition Policy BRICS Conference. As the Program Director has already done, she has introduced the esteemed panel for today's discussion. And of course, I can note and I can see that India has some advantage on this panel because from South Africa, we brought an Indian to represent us. So India is 2-1 up. But hopefully that advantage will be overturned at this World Cup. We will see who will eventually be the champion. This plenary session will be on new issues in competition law and policy in BRICS countries. The BRICS nations have made significant advancements in establishing effective competition law regimes. However, they now grapple with intricate challenges posed by the digitalization of markets and the advent of emerging technologies. These challenges encompass aspects such as digital market structures, behavioral biases, data privacy concerns, outdated regulations, and evolving public policy initiatives. Collaborative efforts among BRICS nations can foster a level playing field in the global marketplace, encourage competition, facilitate knowledge sharing, and eliminate barriers imposed by tech giants. Ultimately, this will promote fair trade, enhance consumer welfare, and ensure transparency in digital markets. Discussing how antitrust authorities respond to these challenges and sharing lessons from their experiences will be crucial in navigating the evolving landscape of digital markets. And for this, we have an esteemed panel of the BRICS countries and from the BRICS competition authorities, as well as academia. I will hand over as we start to Ms. Sweta Kakad, who is the member of the CCI India. Thank you.
Good afternoon, ladies and gentlemen. The topic this afternoon is new issues in competition law and policy in the BRICS countries. Competition law is quite unique in the sense that while the broad legal rules may remain constant over the years, the application of such rules has to be dynamic. Since the law is aimed at regulating the markets which are ever evolving in nature, its application has to adapt to such dynamism. I am aware there are novel issues which are forming part of law and policy debates in the field of competition law. Some are imminent, requiring immediate enforcement and regulatory treatment, while others are more relevant from the discussion point of view, like sustainability concerns, issue of labor, gender, etc., as part of overarching competition law assessment. Today, I will try to cover competition issues which have been at the forefront in India. While we speak about new issues in competition law and policy, digital markets assume relevance. They have been a focal point of our attention and intervention in the last few years, and of other competition authorities across the world. Market dynamics are evolving swiftly, driven by the emergence of digital platforms and mobile applications that offer consumers with diverse products and services at greater convenience. The heightened reliance on online platforms of distribution and transaction during the pandemic has contributed to the growth and consolidation of digital platforms, making them more influential. Even in the post-pandemic world, the preference towards such modes of transaction seem to have become permanent and an irreversible feature. The trend has resulted in increased dependence on limited group of large technology platforms by business users and their customers. Given their control over user data and online presence, these platforms are in a unique position to shape and influence consumer choices on the one hand, and to steer consumer traffic on the other, thus attaining a critical position for business users to reach the end users and vice versa. This critical gatekeeper position, coupled with their inherent characteristic, raises concerns for competition and contestability. Even seemingly small actions by these platforms can result in exclusion and marginalization of the competition, distorting the landscape of competition amongst the business users, leading to large economy-wide ramifications. Eliminating such anti-competitive conduct at the earliest is thus at utmost importance to maintain the level playing field for the businesses. New age market platforms have been the subject matter of the Commission's attention in last few years. Though they brought novel issues and concerns, the Commission has been successful in dealing with most of them under the existing competition regime, as the Act, instead of condemning the specific conduct, lays down principle-based categories which are not conduct-specific. Last year has been phenomenal from the standpoint of enforcement in digital market, deriving legal sanctity from the applicable principles and adopting sound economic reasoning. The Commission issued 3 important antitrust decisions: the Google Android matter, the Google Play Store billing matter, and the Make My Trip matter. Though these matters are currently pending at different appellate forums, I would like to share a few details. The Google Android matter related to licensing and Android mobile operating systems and various proprietary mobile applications. It was found that Google guaranteed a continuous access to search queries of mobile users, which helped not only in protecting an advertisement revenue, but also to reap the network effect through continuous improvement of services to the exclusion of its competitors, resulting in foreclosing the market for them as well as eliminating choice for users. The Commission in this case ordered cease and desist and issued certain behavioral remedies. Along with that, the Commission imposed a penalty of USD 161 million. In Google Play Store billing matter, the Commission found that access to the Google Play Store for Android app developers offering paid app and in-app purchases was made conditional upon mandatory use of Google's Play's billing system. Such imposition left the app developers bereft of an inherent commercial choice to use payment processor of their liking. In this case as well, the Commission imposed behavioral remedies as well as a penalty of USD 115 million. In the matter relating to online mediation services for booking of hotels in India, the Commission found Make My Trip and GoIbibo abusing their dominant position as a group by imposing parity obligations along with dip discounting and exclusivity conditions. This conduct created an ecosystem and impacted competition in the market for online travel agencies besides affecting hotels. Further, a vertical arrangement between MMT and a downstream hotel chain aggregator OYO was found to be anti-competitive as it resulted in vertical foreclosure to the downstream entities competing with OYO. In the said case also, the Commission imposed a penalty of USD 27.5 million on MMT Go and a penalty of 20.7 million USD on OYO. The Commission in these cases has taken a very nuanced view, has applied innovative theories of harm, and tailored the remedies to effectively address the competition distortions, especially considering the specificities of large digital markets. Currently, the Commission is investigating other digital market players as well. Ladies and gentlemen, apart from the ex-post enforcement route, the need for ex-ante measures to regulate the conduct of big tech technical players has gained prominence. The procedure under the ex-post framework are time-consuming, allowing the market to tip with one or two players. Due to the dynamic nature of the market, repeating the adjudication process of the identified practices for a product or a service or for each digital platform may not be desirable, as the procedural delays may cause irreversible harm to competition. So while procedural fairness is important, the need for timely interventions cannot be overlooked. This led to a growing consensus towards ex-ante regulation of digital platforms to supplement the existing ex-post enforcement antitrust rules for an effective and robust regulatory framework. Ex-ante measures will set rules of how tech companies can operate, thus preventing anti-competitive behavior from happening in the first place. The need to strike a fine balance between over-intervention, innovation, and consumer benefits will have to be factored in. India, being the second largest in terms of digital consumer base in the world, has initiated steps in this direction. In December 2022, a standing committee of the Indian Parliament presented a report on anti-competitive practices by big tech companies. It identified 10 anti-competitive practices in the digital market in India, namely platform neutrality, bundling and tying, use of non-public data, search and rank preferencing, etc. Acknowledging the need for a comprehensive ex-ante regulation, the committee recommended that the government should consider introducing a Digital Competition Act to ensure fair, transparent, and a contestable digital ecosystem. Subsequently, in February 2023, the Government of India constituted a committee on digital competition law to examine the need for an ex-ante regulatory mechanism for digital markets through a separate legislation. The deliberations by the committee are ongoing. I am aware that the competition authorities in other BRICS countries are also actively dealing with digital market sectors, and I'm particularly keen to hear from them on how they have dealt with the challenges posed by big techs in their respective markets. Ladies and gentlemen, to provide a further momentum to its enforcement and to bring timely market correction, the Competition Commission was amended in April this year. Few of the amendments I would like to share with you. The most significant amendment on the antitrust side is the introduction of settlement and commitment framework, which is aimed at intensifying fast-track market corrections. They would apply to alleged contraventions related to abuse of dominant cases and certain anti-competitive agreements except cartels. The major difference between them is the time and the stage of inquiry at which the parties can approach the Commission. While the settlement process will get triggered after the investigation report is received, the commitment would take place after the order is passed by the Commission, but before the initiation of the investigation. The leniency plus regime will boost our enforcement against cartels. It is aimed at encouraging companies already under investigation for one cartel to report other cartels unknown to the Commission. The amendment linking to maximum imposable penalty to global turnover instead of the recurring practices of levying it to their turnover within the country is expected to create better deterrence and incentivize disclosure of cartel conduct. On the merger side, a gap was noticed in the asset or turnover threshold to review transactions in digital markets and test their anti-competitiveness. The introduction of deal value as an additional notification criteria will cover those combinations where the actual competitive significance of the entity being acquired is not reflected by the asset turnover threshold. Further, the time for approval of mergers and acquisitions stand reduced from 210 to 150 days, with a mandate to the Commission to form a prima facie opinion in 30 calendar days, otherwise such transactions shall be deemed to have been approved. The Commission is in the process of coming up with detailed regulations for the working of the new amendments. The final regulations will be published, taking into account the comments and suggestions received from public consultation. Before I conclude, let me briefly touch upon sustainability, which, though perceivably unconnected with economic goals, has received and gained a lot of prominence in antitrust discourse. In India, the jurisprudence is yet to evolve, as sustainability concern has not been actively highlighted in any of the cases dealt with by the Commission. It is my understanding that if and when such concerns will arise, they will be dealt with in the overall assessment framework mandated under the Competition Act. The preamble of the Act is quite broadly worded to include economic development of the country and recognizes protection of consumer benefits as one of its goals. Further, there are various provisions under the Act which will aid the Commission while gauging the net impact. With these remarks, I look forward to hearing the other panelists and understand how they have dealt with newer antitrust issues and challenges in their jurisdiction. Thank you.
Thank you, Madam Kakad, for those remarks and for outlining the interventions in India in digital markets, and more importantly, setting out the legislative changes that have been adopted the ex-post enforcement measures, as well as the need for ex-ante regulations. So thank you very much. This is quite instructive, and it does show that through really targeted action, we can address these challenges. Thank you very much. Now I will turn to Mr. Victor Oliveira Fernandes, who is the Commissioner of CADE in Brazil. Over to you.
Thank you, Regine. Hello to everyone once again. And for this contribution, I would like to share with you some recent updates about the enforcement of CADE in digital market, and I will also share some thoughts about sustainability as well. So in Brazil, we have a vibrant digital economy, and we have been facing several new challenges regarding that. CADE has the legal power to employ a competition law which was enacted in 2011, and I would say that this legislation is quite flexible to tackle abuse of dominance cases even in zero price markets. Regarding our track record so far, CADE has ruled several important cases in terms of abuse of dominance cases involving digital platforms. In 2019, CADE has ruled 3 cases against Google. The most famous case in that group is definitely the Google shopping case, which was ruled by CADE in 2019. And back then, CADE has considered that Google was not guilty for self-preferencing the results in the Google shopping page. And over the last years, we have opened new investigations against big tech companies. We now have around 5 procedures against these companies involving cases such as the Google Android case, the Apple Store case, the Meta Jedi Blue agreement case, and so on. So pretty much the cases that are being discussed globally. But apart from these high-profile cases that are investigated in a global scale, in the last years, CADE has undertook some very interesting market investigations and in practice involving some regional dominant platforms in Latin America. In recent years, CADE's enforcement efforts have primarily targeted most favored nations and exclusively clauses adopted by some regional dominant platforms. In 2 recent cases, for instance, CADE used interim measures in the sector for the intermediation of fitness studio and the online food delivery sector as well. In both cases, the practice that was under investigation was the adoption of exclusive agreements and MFN clauses. In both cases, CADE has adopted a balancing rule of reason approach, and then CADE has reached a cess and desist agreement with the companies and putting some limits on the adoption of exclusive dealing in these sectors of food delivery sector and intermediation of fitness studios. Regarding mergers, CADE has been quite active in reviewing mergers involving digital platforms in Brazil. In terms of procedures, our merger threshold is still based on a turnover criteria, but nevertheless, we have managed to review more than 100 mergers that are somehow related to digital platforms over the last 5 years. During this period of time, online advertising and online retail sectors were the most affected by mergers and acquisitions activity in Brazil. Some of the cases raised new theories of harm that are bringing up a lot of attention from the competition authority. And some of these new theories of harm can be exemplified as a data foreclosed theory of harm. If a firm might be able to get access to data that might pose some competitive advantage to them. Some privacy degradation theories of harm as well. So there are a few mergers that have raised this kind of concern. And finally, new conglomerate theories of harm related to digital ecosystems. An interesting example of this comes from the recent decision of CAGI in the Activision Blizzard Microsoft case, which was ruled by CAGI in October last year. So in this transaction, CAGI raised two main theories of harm based on ecosystem discourse. First, we have assessed whether the merger would increase Microsoft's incentives to foreclose its own digital ecosystem to competitors in several markets. Secondly, we have assessed whether the merger would stifle potential innovation in the market of distribution of digital games via multi-gaming subscription service and cloud gaming service. So these are pretty much our updates in terms of enforcement in digital markets. It's also mentioning to share with you that we are having some discussions about the adoption of ex-ante initiatives as well in Brazil. In November last year, it was filed before the National Congress the first proposal of digital platforms competition regulation in our country. And this proposal is deeply inspired by the European Union Digital Markets Act, as it is painted by the congressman who was the author of this proposal in Brazil. This proposal is quite intriguing because on the one hand, it says that it has this inspiration in the EU Digital Markets Act, but on the other hand, there are some very relevant differences that aim for pushing a Brazilian unique approach in terms of ex-ante legislation. And this bill is also very controversial in Brazil right now, as it grants the power to apply these ex-ante measures not to CADE, the competition authority, but rather to the telecommunications authority in Brazil. And that came as a sort of surprise in our country, but that is the design of the legislation, the bill proposal so far. And I think that that might bring some challenges in how to coordinate powers of the antitrust agency and the telecommunications agency. And I would also pose that CADE has a very interesting track record about digital platforms investigation that might be not being considered by this proposal. So, and last, I would like to make some points about sustainability agreements, which also was a topic that was raised by Suita. And I think that given this lack of harmonization, I would say, about how to handle sustainability agreements in competition under competition law, a crucial question that is coming in Brazil right now is how antitrust agency would have not a clearly articulated policy position on that topic should hand green initiatives among competitors. This dilemma is said to become increasingly significant given the international scope of these initiatives. And in this year, CADE has ruled a very interesting case regarding sustainability agreements. And CADE has undertook a comprehensive review of a joint venture agreement focused on the operation of an innovative platform designed to standardize sustainability metrics within the global food supply chain. So it's a very interesting case. And in this case, the platform that was built by the parties was engineered to enhance the management of various forms of sustainability data, including product traceability information, such as origin, environmental metrics like agricultural practice, water use, energy consumption, chemical use, and so on. And this CAGI recent ruling provides a very nuanced perspective on how antitrust agencies should deal with that topic. It refines some antitrust safe harbors discussed in some guidelines, such as the European Union recent horizontal guidelines. And this CAD's decision also provides insight into how competition agencies should limit data-driven initiatives that are being designed for so-called sustainability proposals. But I think that there are the main updates that I would like to share with you, and we are very eager to engage in a discussion about these new topics and within the BRICS countries. So thank you.
Thank you, Commissioner Fernandez, for detailing the interventions of Brazil in digital markets, and more importantly, the enforcement action, new investigations against both regional and international platforms, major regulation measures, as well as ex-ante regulatory measures. So thank you very much for sharing that experience. I now hand over to the head of the Federal Anti-Monopoly Services of the Russian Federation, Mr. Maxim Shaskolsky.
Thank you. Уважаемые коллеги, добрый день. В своем выступлении я затрону две темы: текущее направление деятельности ФАС России, а также результаты и перспективные направления сотрудничества конкурентных ведомств БРИКС. Приоритетные задачи, поставленные перед службой Национальным планом развития конкуренции в Российской Федерации на 2021-2025 годы. Среди них совершенствование антимонопольного законодательства в условиях цифровой экономики, развитие малого и среднего предпринимательства, создание новых рабочих мест, обеспечение устойчивости социально значимых товарных рынков и многие другие. ФАС продолжает уделять повышенное внимание совершенствованию антимонопольного законодательства и развитию правоприменительной практики на цифровых рынках. В сентябре 2023 года вступил в силу так называемый пятый антимонопольный пакет, включающий два закона, вносящих изменения в Закон о защите конкуренции и в Кодекс об административных правонарушениях. Изменения направлены на совершенствование антимонопольного регулирования цифровых рынков, в том числе в части пресечения злоупотребления доминирующим положением, государственного контроля за экономической концентрацией и пресечения антиконкурентных соглашений. В Закон о защите конкуренции введены понятия «сетевой эффект» и «цифровая платформа». Сетевые эффекты могут служить серьезным препятствием для выхода на рынок, поскольку одним из условий для этого становится достижение определенного уровня спроса и числа клиентов, сопоставимых с сетевым эффектом, достигнутым конкурентом. Закон о защите конкуренции дополнен статьей, в соответствии с которой хозяйствующим субъектам, владеющим цифровой платформой, при наличии в совокупности ряда условий запрещаются действия, квалифицируемые как злоупотребление доминирующим положением. К этим условиям относятся сетевой эффект, который дает возможность оказывать решающее влияние на общие условия обращения товара на товарном рынке или устранять с этого рынка других хозяйствующих субъектов, либо затруднять доступ на него другим хозяйствующим субъектам. Доля сделок, совершаемых между продавцами и покупателями посредством цифровой платформы, превышает 35% общего объема сделок, совершаемых на соответствующем товарном рынке. Выручка такого хозяйственного субъекта за последний календарный год превышает 2 миллиарда рублей. Кроме того, согласно изменениям, введенным пятым антимонопольным пакетом, в качестве дополнительного отягчающего обстоятельства при совершении правонарушения, выражающегося в заключении и реализации антиконкурентного соглашения, установлено использование компьютерной программы, позволяющей осуществлять принятие решений в автоматическом режиме без участия человека. Пятый антимонопольный пакет разработан с учетом текущих экономических реалий и практики ФАС России, включающие дела в отношении цифровых компаний. За последнее время нами рассмотрены дела в отношении таких глобальных цифровых платформ, как Apple, Google, Microsoft, Booking. В 2022 году за необоснованные блокировки и удаление аккаунтов пользователей YouTube ФАС России признала Google виновной в злоупотреблении доминирующим положением. На компанию наложен штраф в размере около 34 миллионов долларов США. Компания не выплатила штраф в установленный период, в связи с чем летом текущего года суд удвоил размер штрафа до 68 миллионов долларов США. Ранее ФАС России выдала Google предупреждение об устранении запрета для разработчиков на использование в магазине приложений альтернативных способов оплаты. Предупреждение было исполнено. Теперь российские пользователи могут оплачивать российские цифровые товары любым удобным способом. ФАС России признала нарушителем антимонопольного законодательства компанию Apple. Компания также запрещала разработчикам использовать в Apple Store альтернативные способы оплаты. ФАС России предписала устранить нарушения. В январе 2023 года на компанию наложен штраф в размере более 17 миллионов долларов США. Компания пыталась оспорить штраф, однако суд первой инстанции поддержал позицию ФАС России. Важно отметить, что в своей работе мы стремимся сочетать контроль со стороны государства и активное применение механизмов мягкого права, в том числе на цифровых рынках. В 2022 году ФАС России и крупнейшие IT-компании подписали принципы взаимодействия участников цифровых рынков. Документ направлен на создание института саморегулирования. Участники рынка добровольно взяли на себя обязательство не осуществлять недобросовестных практик по отношению к потребителям или конкурентам. Дальнейшее развитие положения из принципов взаимодействия участников цифровых рынков получили в виде стандартов взаимодействия маркетплейсов и поставщиков, которые конкретизируют общие положения применительно к сфере онлайн-торговли с участием маркетплейсов. Также в настоящее время продолжается подготовка стандартов взаимодействия маркетплейсов и владельцев пунктов выдачи заказов, принятие которых будет способствовать решению ряда системных проблем в указанной сфере. Кроме того, представители маркетплейсов, правообладателей и ФАС России разработали свод добросовестных практик по взаимодействию маркетплейсов с правообладателями и продавцами в рамках предотвращения реализации контрафактной продукции. Применение подобных практик позволит повысить эффективность пресечения случаев реализации контрафактной продукции и защитить интеллектуальные права на онлайн-платформах. Возможно, эта тема также заинтересует наших коллег из БРИКС. Учитывая трансграничный характер рынков, мы стремимся распространить положительный опыт в данной сфере на международный уровень. В июне 2023 года утверждены модельные принципы и стандарты деятельности участников цифровых рынков государств-участников Содружества независимых государств. Аналогичная работа продолжается и на пространстве БРИКС. Считаем важным развивать эту деятельность. Убежден, взаимный обмен опытом между нашими конкурентными ведомствами позволит усовершенствовать механизмы регулирования цифровых рынков и будет способствовать созданию прозрачных правил ведения бизнеса на пространстве БРИКС. ФАС России продолжает уделять пристальное внимание развитию конкуренции и контроля за соблюдением антимонопольного законодательства на социально значимых рынках. Проводится постоянный мониторинг цен на продукты питания и в случае обнаружения нарушений принимаются адекватные меры реагирования. На рынках социально значимых продовольственных товаров развивается практика ответственного ценообразования, когда участники берут на себя добровольные обязательства по ограничению собственных цен или наценок. В апреле 2023 года правительством Российской Федерации издано постановление о случаях допустимости соглашений между органами власти субъектов Российской Федерации и торговыми сетями о сдерживании цен на продукты питания, которые включены в перечень социально значимых. Также для защиты и развития конкуренции в агропромышленном комплексе с целью его бесперебойного функционирования ФАС России на постоянной основе осуществляет контроль за недискриминационным доступом к субсидиям для сельхозтоваропроизводителей. Оптимизирован механизм перерегистрации цен на препараты из перечня жизненно необходимых важнейших лекарственных препаратов. Это позволило обеспечить их бесперебойное производство и поставки на российский рынок, исключило случаи необоснованного роста цен. Услуги операторов сотовой связи также являются социально значимым рынком. ФАС России регулярно проверяет устанавливаемые операторами связи тарифы на предмет их экономической обоснованности. В 2022 году 2 из 4 крупнейших операторов мобильной связи в России необоснованно повысили стоимость услуг сотовой связи для более чем 44 миллионов абонентов. ФАС России пришла к выводу, что повышение тарифов в отсутствии технологического, экономического или иного обоснования нарушает интересы потребителей. Операторам выданы предписания о необходимости снижения тарифов. Одному оператору до экономически обоснованного уровня, а второму о полной отмене повышения. Осуществляется мониторинг цен на рынке строительных материалов с целью контроля уровня цен и недопущения случаев злоупотребления доминирующим положением. В 2022 году в ФАС России выявлены нарушения антимонопольного законодательства путем злоупотребления доминирующим положением на рынках горячекатанного плоского проката, листового стекла, древесных материалов, газобетонных блоков, линолеума. По итогам рассмотрения дел выданы предписания об осуществлении действий, направленных на обеспечение конкуренции. В этом году служба выявила признаки нарушения антимонопольного законодательства на рынках цемента, арматуры, сырья, используемого для производства керамической плитки. В ходе рассмотрения дел ФАС России будет проведен комплексный анализ ситуации. В случае подтверждения нарушений приняты меры антимонопольного реагирования. Борьба с картелями остается одним из приоритетных направлений деятельности ФАС России. В рамках работы по пресечению картелей ФАС России и ее территориальные органы в 2022 году возбудили более 300 дел. Лидерами по количеству выявленных дел по-прежнему остаются рынки строительства, в том числе автомобильных дорог, поставки медицинских изделий, жилищно-коммунальное хозяйство. В связи с заключением антиконкурентных соглашений вынесено около 1000 постановлений о наложении административных штрафов на общую сумму более 50 миллионов долларов США. Изменения, которые регламентируют порядок подачи и рассмотрения антимонопольным органам заявления хозяйствующих субъектов о заключении ими антиконкурентных соглашений. На законодательном уровне закрепляется определение очередности и приоритетности поданных в антимонопольный орган заявления, то есть усовершенствована система маркеров. Контроль за экономической концентрацией продолжает оставаться одним из ключевых элементов антимонопольного регулирования. В 2022 году в ФАС России рассмотрено более 1200 ходатайств о возможности совершения сделок. В рамках оптимизации, цифровизации деятельности работаем над представлением компании возможности подать ходатайство в электронном виде. Также в части контроля за экономической концентрацией в 2023 году в Закон о защите конкуренции введено новое основание, по которому сделки с акциями и долями коммерческих организаций должны совершаться с предварительного согласия антимонопольного органа. Это превышение цены сделки 70 миллионов долларов США. Нововведение позволит учитывать подлинную ценность компании, поскольку традиционные критерии, основанные на сумме выручки участников сделок или величине их активов, не всегда могут отражать реальное влияние сделки на состояние конкуренции на рынке. Кроме того, внесены изменения, дающие сторонам сделки право заявлять о добровольных обязательствах для обеспечения конкуренции на рынке. Появляется возможность привлечь эксперта при рассмотрении сделок экономической концентрации, а также в рамках контроля за исполнением предписаний. Мы не забываем о необходимости снижения административной нагрузки на добросовестных участников рынков. ФАС России с каждым годом все активнее использует институт предупреждения или предостережения. Мы направляем в адрес лиц, публично заявляющих о планируемом поведении на товарном рынке, предостережение о недопустимости совершения подобных действий с целью предупреждения нарушения антимонопольного законодательства. В случае обнаружения признаков недобросовестных практик мы также направляем компаниям предупреждения. Применение этих превентивных мер привело к снижению количества дел о нарушении антимонопольного законодательства в 2 раза за последние 5 лет. Кроме того, данные механизмы позволяют оперативно устранять нарушения. В результате в короткие сроки восстанавливаются условия конкуренции на рынках, а граждане и бизнес быстрее восстанавливают свои нарушенные права. Мы продолжаем уделять большое внимание мерам поддержки и развития малого и среднего предпринимательства. В рамках применения рискоориентированного подхода минимизировано количество проверок объектов малого и среднего предпринимательства. В 2022 году по инициативе ФАС России субъектам малого и среднего предпринимательства предоставлена возможность уплаты половины суммы от наложенного административного штрафа по факту заключения антиконкурентных соглашений. Упрощен порядок согласования с антимонопольным органом сделок экономической концентрации, суммарная стоимость активов которых составляет от 10 до 24 миллионов долларов США. ФАС России организовано постоянное взаимодействие с бизнес-сообществом, в том числе производителями, цифровыми платформами, торговыми сетями, различными ассоциациями и общественными организациями. Продолжается активная работа по адвокатированию конкуренции. Регулярно заявляется о необходимости социально ответственного ценообразования, внедрения антимонопольного комплаенса. Далее остановлюсь на перспективных направлениях совместной работы конкурентных ведомств БРИКС. В рамках реализации меморандума о взаимопонимании конкурентных ведомств БРИКС, подписанного в 2016 году в Санкт-Петербурге, мы продолжаем тесное сотрудничество, основанное на обществе интересов и взаимной выгоде по всем стратегически значимым вопросам. Приветствуя присоединение к БРИКС новых членов, необходимо отметить, что мы уже имеем опыт сотрудничества с конкурентными ведомствами ряда приглашенных стран, и мы будем рады укреплению такого взаимодействия на многосторонней основе. За текущий год мы успешно провели заседание рабочих групп БРИКС по картелям по исследованию проблем конкуренции на автомобильных и продовольственных рынках. Через месяц проведем заседание рабочих групп БРИКС по исследованию проблем конкуренции на цифровых и фармацевтических рынках. Учитывая высокую социальную значимость продовольственного рынка для мирового сообщества, предлагаю в ближайшей перспективе провести масштабное секторальное исследование продовольственного рынка в формате БРИКС+. Подобное исследование даст возможность осуществить сравнительный анализ обеспеченности населения основными продуктами питания, а также оценить эффективность мер антимонопольного регулирования в странах БРИКС и странах-партнерах. Важную экспертную поддержку деятельности конкурентных ведомств БРИКС оказывает Международный центр конкурентного права и политики БРИКС. Предлагаю более активно использовать потенциал центра и привлекать к совместной работе его экспертов. Убежден, что симбиоз практических навыков антимонопольных органов и научных знаний экспертов Центра будет способствовать совершенствованию антимонопольного правоприменения в странах БРИКС. Продолжается взаимодействие в рамках рассмотрения сделок экономической концентрации с целью обсуждения подходов и принятия наиболее взвешенных решений. Мы систематически информируем друг друга о глобальных слияниях в наших странах, которые потенциально могут заинтересовать другие юрисдикции. При рассмотрении сделок мы активно используем модельные рекомендации БРИКС по использованию механизма отказа от конфиденциальности вейвера, принятые в 2021 году, что позволяет нам во всей полноте обсуждать природу сделки, подходы к ее оценке и обмениваться необходимой информацией. Нами также активно применяются инструменты международного сотрудничества, зафиксированные в документах международных организаций, в том числе в руководящих принципах и процедурах в соответствии с секцией F комплекса по конкуренции ООН, которые были разработаны по инициативе ФАС России при поддержке ряда конкурентных ведомств, в том числе и стран БРИКС. Конкурентные ведомства БРИКС также расширяют сотрудничество в области борьбы с антиконкурентным поведением крупных транснациональных корпораций, в том числе с международными картелями. Нами ведется работа по созданию и усовершенствованных механизмов борьбы с подобными практиками на профильных международных площадках. При содействии и поддержке государств-членов БРИКС инициирована беспрецедентная по своему масштабу работа на площадках ЮНТАД в рамках рабочей группы ЮНТАД по трансграничным картелям. Выражая надежду, что результатом деятельности этой рабочей группы станет создание глобальных стандартов международного сотрудничества при расследовании трансграничных картелей. В завершение хочу подчеркнуть, что результаты нашего взаимодействия демонстрируют значимую роль антимонопольных органов БРИКС в формировании мировой конкурентной повестки. Уверен, что совместными усилиями нам удастся улучшить качество правоприменительной деятельности стран БРИКС, повысить эффективность проводимых расследований для достижения положительных эффектов на благо населения и экономик наших стран. Спасибо за внимание.
Thank you very much, Mr. Szaskolski, for sharing that detailed experience and interventions in Russia, not only in digital markets, but also broadly. But more importantly, you have outlined the legislative changes to address the challenges in digital markets, specifically emphasizing the need to look at network effects broadly as a filter to assess the conduct that we should be concerned of. You have also outlined the enforcement measures, the use of soft law measures, and something new that you have put here is focusing on combating the sale of counterfeit products through these digital platforms, and more broadly looking at what can be the interventions and your own interventions in socially sensitive markets. You have mentioned, issues on major regulation, and also the need, and I think we have our very own center, which is the BRICS Competition Law and Policy Center, as the center for developing this knowledge for ourselves. So it's our own center, and we should utilize this. And finally, the need, of course, to promote international cooperation under the auspices of UNCTAD and within BRICS. And you have reminded us that, and it will happen in January next year, that BRICS will be expanding. So we will be welcoming a new family of the competition authorities into our new family. So we have to start thinking about how we integrate the new authorities. So thank you very much for those remarks. I now hand over to the Vice Minister of the State Administration for Market Regulation of China, Madam Gan Lin. Madam, over to you.
谢谢各位同仁，下午好。很高兴与大家分享中国竞争政策实施和反垄断工作的最新进展。2年前，第7届金砖国家国际竞争大会在中国成功举办以来，我们不断地完善公平竞争制度规则，切实提升反垄断监管执法效能，持续深化竞争领域交流合作。中国竞争政策实施和反垄断工作迈上了新台阶， 取得了新成效。具体的话有5个方面的成效：一是修改反垄断法律制度，完善了公平竞争规则。为了适应高质量发展新要求和数字经济的新特点，中国在2022年6月完成了反垄断法实施14年后的首次修改，将鼓励创新纳入了立法目的，将强化竞争政策基础地位上升为法律规定，进一步完善数字经济治理规则，强化法律责任。修改后的法律已于去年8月1号开始施行。我们加快完善反垄断配套立法，推动修订经营者集中申报标准，起草公平竞争审查条例草案，发布禁止垄断协议规定、禁止滥用市场支配地位行为规定等5部反垄断配套规章，不断地增强法律制度的可操作性和可预期性。目前，中国已经形成以反垄断法为核心1部行政法规、6部部门规章和8部反垄断指南构成的反垄断的法律体系，夯实了保护和促进市场公平竞争的法治根基。二是健全反垄断体制机制，提升了监管执法效能。2021年11月，市场监管总局加挂国家反垄断局牌子，充实反垄断监管力量，增设了反垄断执法1司、执法2司、竞争政策协调司3个反垄断司局，分别负责垄断协议和滥用市场支配地位行为的执法、经营者集中审查、滥用行政权力排除限制竞争执法等职责。同时，组建竞争政策与大数据中心，加强反垄断理论和技术支撑，构建起统筹协调、整体联动、运转高效、监管有力的反垄断的工作格局。2022年8月，市场监管总局委托试点5个省级市场监管部门开展经营者集中反垄断审查，进一步构建央地两级分级分类审查机制，为各类经营主体提供更加便捷高效的监管服务。3是加强反垄断监管执法，保护了市场公平竞争。我们始终坚持监管规范和促进发展并重，持续加强民生发展重点领域常态化反垄断监管执法，当好公平竞争的维护者、消费者利益的保护者和高质量发展的推动者。2022年以来，先后部署开展制止滥用行政权力、排除限制竞争执法专项行动、民生领域反垄断执法专项行动，依法查处重大典型垄断协议、滥用市场支配地位案46件，罚没金额16.45亿元，审查经营者集中1280件，纠正滥用行政权力排除限制竞争行为86件，切实维护市场公平竞争的秩序，保护消费者利益，激发经营主体创新活力和发展动力。同时，全面落实公平竞争审查制度，审查新增政策措施30.79万件，清理存量政策措施76.35万件，废止修订纠正妨碍统一市场和公平竞争的政策措施3.7万余件，推动构建高效规范、公平竞争、充分开放的全国统一大市场。4是开展竞争倡导，强化公平竞争理念，打造中国公平竞争政策宣传周平台，加强竞争宣传主阵地建设，集中展现保护和促进公平竞争的工作成效， 大力弘扬公平竞争文化，得到经营主体和社会各界的热烈响应。连续4年发布中英文版《中国反垄断执法年度报告》，及时公布垄断案件行政处罚决定和经营者集中案件的审查决定，集中发布反垄断执法典型案件，不断提升反垄断执法透明度，通过以案释法增强经营主体反垄断合规意识和能力，制定发布经营者反垄断合规指南、经营者集中反垄断合规指引等等，针对各级行政机关和各类经营主体开展宣传培训，大力营造公平竞争的社会氛围。5是加强交流合作，深化竞争领域对外开放，始终坚持全球视野，秉承开放思路，不断加强竞争领域的国际合作，与全球35个国家和地区签署了59份竞争领域的合作文件，在15个多双边自贸协定和中国协议中设立竞争政策的议题，推动提升国际贸易投资自由化便利化水平，加强与金砖各国竞争机构合作，发布成都联合声明等成果文件，促进金砖国家竞争领域合作进一步走深走实。连续举办10届中国公平竞争政策国际论坛，不断深化与其他国家和地区竞争执法机构的沟通交流和务实合作，积极参加多双边国际会议，分享中国经验，贡献中国智慧，共同维护公平竞争市场秩序，促进更高水平对外开放。公平竞争是市场经济的内在要求，是经济发展的动力源泉，是国际经贸往来的重要基础。当前世界正在经历大调整、大分化、大重组，不确定、不稳定、难预料因素增多。金砖国家竞争政策实施和反垄断工作也面临新形势、新任务、新挑战。我们需要深刻理解经济运行规律、产业发展规律和竞争监管规律，准确把握竞争政策实施和反垄断的方向和重点，为推动高质量发展和经济全球化营造良好的市场竞争环境，为世界注入更多确定性、稳定性、正能量。在此呢，我也提出4点意见和建议。一是要进一步发挥竞争政策实施在促进经济复苏中的重要作用。国际经验表明，加强竞争政策实施和反垄断工作，有利于保护市场竞争，推动经济增长，降低通胀影响，提振发展信心。在经济下行时期，更要统筹协调竞争政策与产业政策，大力营造公平竞争的市场环境，支持和刺激经济复苏。我们要深刻理解，竞争政策就是发展政策的科学内涵，加快构建公平、透明、稳定、可预期的公平竞争规则，有效破除制约经济畅通循环的垄断堵点，使发展动力在公平竞争中竞相迸发，充分涌流，努力为各类经营主体拓展更大竞争发展空间，助力各国经济加快复苏，走向繁荣。2是要进一步发挥竞争政策实施在促进新兴产业创新发展中的重要作用。当前互联网、大数据、人工智能等现代信息技术突飞猛进，数字经济蓬勃发展，以强大算力为基础的各种模型和算法不断涌现，新技术、新产业、新业态、新模式日新月异。人类社会正在经历一场更大范围、更深层次的科技革命和产业变革，正在加速迈向智能世界。世界各国都普遍认识到，数字经济 已经成为经济发展的新动能，但同时也带来了很多新的竞争问题。加强数字经济反垄断监管已经成为全球共识。我们要坚持监管规范和促进发展并重的工作方针，准确把握活力和秩序、竞争和创新的关系，健全与企业的常态化沟通交流机制，统筹事前预防、事中规范和事后处置，为新经济发展营造公平竞争的良好环境，为经营主体创造更加广阔的发展空间，为经济增活力，为发展添动力。三是要进一步发挥竞争政策实施在保护消费者利益中的重要作用。增进民生福祉是发展的根本目的，加强反垄断监管，保护市场公平竞争，可以使广大中小企业有更多竞争机会和更大发展空间，使广大消费者享受更加优质的产品和更为公平的价格，实现更加平衡、协调、包容发展。特别是当前市场竞争格局加速重塑、赢者通吃、强者愈强和竞争国际化等特点明显，对保护中小企业和消费者利益提出更大挑战。我们要坚持保护消费者利益和社会公共利益的价值取向，准确高效加强反垄断执法，推动降低市场进入壁垒，助力形成大中小企业良性互动、协同发展良好格局，让更多经营主体和消费者共享发展红利，促进社会公平正义。四是要进一步发挥竞争政策实施在推动经济全球化中的重要作用。当前世界经济来到十字路口，保护主义、单边主义持续蔓延，贸易和投资争端加剧，经济运行的风险和不确定性显著上升。公平竞争制度是国际经贸规则的重要内容，也是金砖国家对话协商、共建共享、交流互鉴的重要桥梁和纽带。竞争规则在国际经贸规则体系中发挥着日益重要的作用。我们要适应经济全球化和企业竞争国际化的发展趋势，更加注重发挥反垄断的开放功能，不断加强国际竞争规则建设和全球竞争治理，为推动经济全球化健康发展提出金砖方案，贡献金砖智慧，为经济全球化深入发展奠定坚实的基础。各位同仁，独木难成林，一花不是春。作为金砖国家中的一员，我们将坚定不移加强反垄断，深入推进公平竞争政策实施，为各类经营主体投资兴业、健康发展营造公平竞争的市场环境，不断扩大对外开放，推动国内市场与国际市场更好联通。我们也很愿意在金砖国家合作机制框架下，与各方持续加强竞争领域务实交流合作，共同参与全球竞争治理，维护国际市场的竞争秩序，促进国际经贸往来不断深化，推动实现可持续发展和包容性增长。我就讲这些，谢谢。
Thank you, Madam Gan, Honorable Vice Minister of Sama, and of course as moderator I tried to summarize, but I don't think I can do justice to the remarks that you have just given. But let me say this, and indeed thank you very much for sharing the experiences and interventions in China, in digital markets, and more broadly in the economy. You have shared experiences on the revisions of the law, competition law in your country, the regulations issued, efficiencies, and improvements under the new regime of the state administration for market regulation, strong supervision across the markets, special actions to enforce the laws in markets affecting livelihoods of people. So this is what we are now accustomed to call as socially sensitive market. And advocacy measures. I think the extensive reviews of laws and policies that hinder the efficient functioning of the market. And you did mention the publication of the law and annual reports in other languages, which I think is a very good step within BRICS also, so that we can access each other's statutes or any other reports that we are able to share. Very strong emphasis on the linkages between competition, regulation, and industrial development, the role of competition policy in economic recovery, looking at new technologies and associated changes. And finally, I think what competition policy means for the consumers, for the people, and their livelihoods, and above all, economic development and prosperity, both within BRICS and our national economies. I thought I mentioned this because I know that the BRICS Competition Law and Policy Center is in the room, that there are a lot of number of topics for that require deeper research that the center can look at. Thank you very much. I now hand over to the principal economist in the Economic Research Bureau of the Competition Commission of South Africa, Harry Prasad Govinda. Harry.
Thank you, Chair. Good afternoon, everyone. In September 2020, Competition Commission South Africa had developed a digital market strategy document. And based on that, we wanted to understand the digital market and to identify the abuse by the dominant firms, especially given network effects, first mover advantage, tipping points, and multi-sidedness, etc. And also to act on killer acquisition that has the potential to remove a maverick firm or a maverick technology or maverick innovation from the market. And we also wanted to look into collusion in digital markets through algorithms and consumer protection issues through the use of personal data. And lastly, the impact of digital markets on broader architecture of industrial structure in the economy. And between 2011 to 2018, we have had 87 mergers in the digital space, 5 of them approved with conditions and the remaining without. And we have had a couple of abuse of dominant cases. One, just to name a few, it's like WhatsApp and GovChat case. It is government citizen engagement services, which was off-boarded by WhatsApp. And we've also had Uber and Bolt e-hailing. There's a complaint by the e-hailing partners council alleging that the excessively high commission fee being charged to the driver partners. While the WhatsApp case, we are waiting for a hearing date for the tribunal, and the Uber case is still under investigation. And in terms of cartel, we have been thinking of launching a forensic lab to detect cartel in the public procurement space. And we also have a very recent cartel case on an e-commerce platform where 2 of the market sellers selling the masks, they had colluded. I could explain the mechanism. It's this e-commerce platform in the country is very similar to Amazon in the way they do the business. So everyone wants to win a buy box. A buy box is generally the cheapest price available on a particular product, especially when that product is in the warehouse. So what these two firms did is to collude on a day. They have to choose. They choose a day and time. At 5 o'clock, you reduce your available stock in the warehouse so that the algos pick up the alternative supplier's product. You increase the price so that even when a consumer inputs a query that I would like to buy a mask on a e-commerce platform, the algos only pick up those masks which are in the warehouse and which are lower priced. But these two firms took turns to increase price one at a time so that the other party wins all the sales. And next day, they would pay back in the similar mechanism. So CCSA, we investigated that case, and now the parties have in dialogue with the Commission for a consent agreement. And ever since we adopted this digital market strategy, we have launched market inquiry into online intermediation platforms, and we included e-commerce, travel, accommodation, food delivery, classifieds, app stores, and few other streams. Unlike investigation, for instance, market inquiries are broader in terms of scope, focusing on distortion to competition, distortions or which can impede competitive process in the market, unlike the investigations where you identify a specific conduct and you go on a particular firm, defining markets and understanding the abuse, and if the abuse is imminent, then penalize. But market inquiries are much more broader, that you only look at broader markets and then identify the distortions in the market. So in the slide, I'm going to focus on the challenges that we faced while we were conducting the market inquiries. So the first and foremost is the capacity building. We are used to a kind of world where we define markets, we understand markets in terms of prices, quantities, volumes, values, very visible kind of parameters that we look into. But when we all of a sudden look into the digital space, what we have is your downloads, clicks, click-through rates, cost per click, cost per impression, bounce rate, visits, minutes spent per page, multi-homing versus single homing, dependency, reliability, discoverability, ranking, paid ads. These are new terminologies, so we need a lot of capacity building in order to investigate cases, and we had to go through such a significant capacity building exercise through our strategy document of the digital markets, and also we had conducted a scoping study into digital markets in order to capacitate our teams. The second challenge that we had faced is the issue of jurisdiction. So if you see, we have inquired the players like Apple, Booking.com, Amazon, Google, including some of the local platforms in various streams. But the kind of firms that we look into here, the Apple, Google, Amazon, and Booking.com, they always use a jurisdictional challenge issue. Since they do not operate in South Africa, they do not have a storefront in South Africa, competition authorities in South Africa, including tribunal, do not have a jurisdiction to impose any action or remedies. And by the way, 2019 provisions, amendments made to the Competition Act makes the recommendation of an inquiry binding unless it is appealed. All the recommendations must be complied by the private entities. But Google, fortunately, is agreed with a consent agreement, so it is agreed to comply with all the recommendations that we have made. But Apple, Booking.com, and Amazon, they are appealing. But we do have a case precedent, banking forex case, where the tribunal has made it a case law that irrespective of whether the firm is operating, physically present in the country or not, as long as it has an impact on the consumers of the country or economic activities taking place in the country, they are subscribed. But despite that case law, some of these firms are still challenging such jurisdictional issues. For me, it looks like an adversarial one, which only delays just in terms of litigation. And we also have had issues of data. When we looked into the App Store stream, we know that Apple and Google charge 30% commission fee on the business users, all the developers. But recently they said everyone who's earning more than $1 million in a financial year will pay 30%, and everyone else earning less than $1 million will be paying 15%. But we never understood even that 15% how it was arrived at. So we asked for data, but the cost data was never, we never received it. Although we could get data for the revenues generated through app stores in the country, you don't get data on costs, cost breakup, cost buildups. So we had to only rely on the global figures, which is your 10K filing, which is filed in US, and you will look at the revenues and cost items for the global business and then see what the markups look like, and you can fairly infer how significantly profitable the businesses are. And that can easily tell us that they are not cost related, and even 15% could be very high. And when we also conducted a survey of business users, first thing is the budget constraint. You outsource because you need to be independent, but the response rate is very, 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 very low. When you have a response rate very low, then you compromise on the statistical properties of the sample which is being surveyed. And next challenge is the constructive remedy design. It has to be reasonable, practical, implementable, and sustainable. You can ask for a sky, but you need to work out a good balance. And also, we have to watch out for unintended consequences. And we had included a variation clause within, because the digital market is fast moving. Anything can change any time of the day. It's very quick. So we had to incorporate an unintended consequence as a clause where there is a significant change in the market, parties could come back and have a consultation with the Commission. And lastly, the consultation process itself is a big process, matching expectation and to reduce the risk of adversarial litigation. Because of this successful consultation process, we have very few appeals for the recommendations of the inquiry, and mostly every other firm have promised, they are obligated to comply with the recommendations. And quickly, in terms of the broader aspect from the Competition Commission South Africa perspective, we have a buyer power enforcement guidelines. What it does is it identifies the designated sectors of online services, and especially the smaller businesses and of the buyer power provisions of the guidelines, and the types of online platforms that fall within the target, so that you know when the dominant firms behave, what is problematic or not. And it also includes restrictions by e-commerce providers on small suppliers, preventing them from accessing and supplying their products and services in their other distribution channels other than the online marketplace. And we have also had amendment in 2018 that introduced the creeping acquisition provisions, which enables authority to prohibit a killer acquisition and other strategic and complementary acquisitions that can give more market power to the players. And CCSA is also revised its small merger notification guidelines to consider implementing a mandatory notification requirements for certain high impact digital mergers, irrespective of the thresholds in terms of assets and turnovers. And lastly, the amendments of the 2018 introduced price discrimination provisions, which enables authorities to prohibit conduct of dominant firms that impedes the effective participation of the historically disadvantaged individual firms and SMEs. This is more prevalent in digital space. Even when you consider the onboarding fee on a platform, the platforms tend to give preference to the bigger firms compared to the smaller ones, and they tend to pay more than the bigger firms. That kind of a differential is quite existing. On the 17th March 2023, CCSA has published the draft terms of reference for the new market inquiry, which is Media and Digital Platforms Market Inquiry, covering search engines, social media, video streaming, and new aggregation platforms. And we were also looking into the generative artificial intelligence, like a ChatGPT. So it's quite a challenging inquiry because we need to know what to ask from the parties when you actually look into the algos. Are we asking for the algos? Do we have capacity to look into, analyze, validate whether what they do and how do they do and how do they function? I'll stop it here. Thank you, Chair.
Thank you very much, Harry, for sharing South Africa's experience in digital markets. In fact, from conception of the strategy to execution through various interventions in enforcement, market inquiries, some soft law that you have referred to, and the impact of the legislative changes. So thank you very much. Professor Rajat Katuria, when I was sitting here, I thought, what are the competition authorities doing to the professor? Because when I look at the timelines, I could see your time being eaten away to the point where we are almost at the tail end of the session. But I think as we try to crowd you out, I think we will crowd out the tea time. There is tea on the one side so that we can at least maybe take a bit of time from it if it's permissible. But I will hand over to you. Professor Katuria is the Dean of the School of Humanities and Social Sciences of the Shiv Nadar University. So I would really request your indulgence so that we can hear fully from our professor. Thank you very much. Over to you.
Thank you, Martin. I don't know how I will compete with tea, but I will try to make my time a little more sort of valuable to all of you. But seriously, I've sort of heard, and what I wanted to say has in some sense already been said. So I will try and add some value conceptually and share my thoughts with you on what I've seen working with digital markets over the last few years in India especially, but also with some sort of experience with the rest of the world. I worked for TRAI at its inception. TRAI is the Telecom Regulatory Authority of India, and all the sort of issues that have been brought up, competition issues that have been brought up for the digital markets really emanate, and I think this was already said before, they emanate from the telecom markets, the digital markets, sort of make these issues probably a little more intense and little more difficult to handle. Telecommunications was probably an easier sector to regulate. It wasn't very easy, but easier than digital markets. So, one of the things that we hear about markets, especially digital markets, and if you look at the old markets before us, the brick and mortar markets before us, it wasn't the case that there was no market failure and therefore abuse of market then. It already existed. There was huge abuse of markets. We've heard about those sort of traditional and also celebrated cases involving the big oil companies, and then coming closer to the digital companies, IBM and Microsoft. They were all sort of had market power, and they were not afraid or they were not unwilling to exercise their market power. But one of the things that I heard, especially as an academic economist, and I was sort of influenced by the readings of some of the American economists who went on to become chief economists of digital companies, that when you have digital markets, they begin to somehow work better, and therefore the need for intervention becomes a lot less. And therefore you may even obviate the need for intervention if you have digital markets which begin to take away the traditional reasons for market failure, which is asymmetric information. Information now flows freely and everybody has access to the same information. So to the extent that asymmetric information is responsible for market failure, you've actually eliminated one of the reasons for market failure. And then another reason, of course, was monopoly. And if you had monopoly power in the traditional, let's say the oil company, or where you had huge capital investments necessary, then there would automatically barriers to entry, and therefore there would be dominance. And also, as I said, companies were sort of willing to exercise their dominance or abuse their dominance, as the case may be. And we were being told then that because markets have now become digital, they are become digital, the barriers to entry are concomitantly reducing, and therefore the need for intervention again becomes a lot less. And as the years have evolved, and I think, and I'll share with you towards the end what I think about this, as the years have evolved, we begin to realize that actually market failure, perhaps, I don't have data on this, but anecdotal readings of maybe some academic papers as well, actually market abuse has become a lot more deeper and pervasive than in the brick and mortar world. I'm willing to stand by the comment that I'm making, but the Robert Bork's analysis was done, the antitrust paradox that government intervention will make things worse, was done at a time when digital markets did not exist. And as digital markets exist, what I was saying about the telecommunications sector, which is that you had network effects, and if you didn't have interconnection, if you were there, no interoperability, companies would become, firms, service providers would become, islands unto themselves and begin to exercise their market power, be it through the gatekeeping function, be it through pricing, be it through excluding other competition, all the usual anti-competitive features that you see in markets. And we thought that as digital markets become more prevalent, the idea of sort of market failure would reduce. But what do we see now? We see, despite interoperability, despite the fact that clouds can talk to one another, there is real fear about migration from one cloud to another. There is real fear about switching costs. There is fear about how companies are going to renew their license and how much you are going to have to pay, etc. All those matters are not only there, they continue to exist, but I think they've become much more pervasive in the digital space. And the reason they've become much more pervasive is because, as the panel has already said, that externalities or the network effects are so dominant that you become big very quickly, and therefore to cut to, let's say, enforcement, if you have a structural remedy, for example, if a competition authority or a court or some jurisdiction recommends breaking down a firm or structural remedies, as we've seen in the US with AT&T and with some recommendation for Google and Microsoft, how would that work? I mean, would that work? Would that have a sustainable impact, or would the firm just become big again, and likely to become very, very big again? So structural remedies, while they may be short-term panaceas, I think in the long term, given the huge network effects in digital markets, they are likely to grow big again. So my first point is that the case for government intervention, or the case for sort of regulatory intervention, whether it's government, mostly government, right? The case for government or regulatory intervention, I think in digital markets is much more than it was in brick and mortar markets, because I think the market failure has become much more intense, not only because of sort of fake information, but the fact that you have data privacy issues and you have huge externalities with firms becoming very, very big. And once you become big, not only is there a tendency to exploit or abuse the market power, there is also a tendency to influence the political economy, although this is not a platform for talking about that, so I will refrain influences on political economy, but bigness or largeness becomes a case. I haven't seen a monopoly in my life as an economist and as my life as even a regulator. I haven't seen any monopoly that is benign. If you spot one, please do let me know. I think monopolies will exploit their power, and there'll be a cat and mouse game, but I think we need to sort of be vigilant. My second point is this debate around ex ante versus ex post regulation. Again, coming from the US Chicago school, ex ante regulation not good. It sort of kills innovation, it compromises innovation. But if you sort of hark back to what I've said about sort of abuse, and if there is a trade-off between innovation and abuse, I will still sort of fall on the side of ex ante regulation. So I think the need for ex ante also it must be I must caveat this by saying that, don't throw rules at a problem. I'm not sermonizing here, but I think throwing rules at a technological problem or trying to say that this rule will affect, will take care of this problem which is generated by technology, that's probably not going to work. That's not what I mean by ex ante rules. We should try and create rules where you allow entry, try and reduce barriers to entry, although I admit it will be difficult. But when I mean ex ante rules is you try and prevent mergers that are likely to kill innovation, what people have been calling kill zones, where innovations are likely to be swallowed by companies to prevent that innovation and competing with them. As I said, nobody likes competition, no firm, no individual, nobody likes competition, so they will try and exploit their sort of market power to be able to limit that competition either today or in the future. So the design of ex ante rules probably necessary, and I think everybody on the table has said that, and we in India are also doing that. So I don't think there is a big case or a strong case to be made out of, markets are working and don't need ex ante rules in digital markets. So I think that's necessary, and for data, of course, it becomes even more necessary. But those rules have to be designed cleverly so that you ensure that you're not going to be able to sort of limit innovations. So the other thing that digitalization or digital markets have done is that they've exposed the point that I was making, that companies have habitually, monopolies have habitually abused their market power. The history of antitrust in the United States, the history of competition or lack of it in India, at least two countries that I know pretty well, there's habitually abused market power. So one example I can give you, I mean, there are cement companies in India that have been, huge fines have been imposed on them by the CCI, and now digital companies. And if you look at the number of digital cases in the world, it is probably at an unprecedented high. So there's no case that they are not abusing their power. But there are some times when you don't know that they're abusing their power, right? I mean, it may be happening, but you are unaware, the competition authority is unaware that power is being abused. And I'll sort of give you an example which struck me when I was working as an economist in a business school, which is that when RFID, I don't know how many of you remember this resale price maintenance in the United States, and when RFID came into being to check inventories, and when data on prices and the prices at which goods were sold and groceries were sold in big grocery stores, especially in the United States, they found that there was a huge abuse of market power, either by the grocery chain or by the brand that was involved, because earlier this information wasn't available, and with information becoming available, the fact that they had been abusing their market power, through various means of shelf space or pricing, whatever you can think of, exclusionary conduct, all of this had existed. So monopolies will do what they have to do, and competition authorities will do what competition authorities have to do. But gathering of information, the fact that you need data and information to be able to actually come up with evidence that this is being done is absolutely necessary. And my predecessor, Govinda, as he said, that I worked in a regulatory authority. You ask telecom service providers for data, and they will ask you, why do you need this data? And you will tell them, okay, I need to calculate the prices. They'll give you one kind of data. Then you ask them, another time you want to use data, and they say, what do you need the data for? Well, I want to calculate interconnection data. Some of the variables are the same, but the data that comes through is very, very different. Now, how that data is being given to you, whether, how do you check the veracity of that data, the truthfulness of that data is difficult. So, you know, then you have to probably go to third sources, go to the US stock markets and get information that has been revealed to the SEC, where hopefully the information is accurate. But the point I'm making is for competition authorities to get access to relevant, truthful, accurate, and usable data is not an easy challenge. And therefore, I think investment by the authorities in getting this data, especially in digital markets, becomes even more important. Remember the case of resale price maintenance, data became available and the abuse became apparent. And similarly, in the case of digital markets, I think if better data is made available and its analysis could perhaps show, I don't know, this is stochastic, I don't know what's happening, but maybe there is something that we yet don't know because that data hasn't been made available to us. So that's my sort of third point. The fourth, I have 5 points to make. So my fourth point is, again, keeping India in mind, and this is obviously it applies to all the BRICS countries and beyond, is that your 2 minutes, okay. Your sort of what you need to do in your local context should be determined by the local context, yeah? And I think it has already been said, because countries and regions operate in a very different environment, although competition issues may be general, but operate. And I'll give you a sort of an example, which I think is relevant. It's not meant as a criticism for any jurisdiction or any country, but as an example to actually manifest what I'm going to say. So it is a personal experience. I was working at the Telecom Regulatory Authority of India several years ago, and so the Washington consensus prevailed at that time, and it continues to sort of affect, although I think it's been undermined a little bit. And the Washington consensus was that regulatory authorities shouldn't be funded by the government if you want independence. Or the best way is that regulatory authorities should be funded by the sector that they're regulating, et cetera, et cetera. I won't use strong language, but I think we need to relook at those sort of paradigms and accepted values that were received wisdom at one point in time. And I think that's not necessarily true, that independence from either government or for the market players can be sort of, it is a very local thing. You can get independence even with funding from government, even by being funded by the operators, you may not get independence. So I think this notion that this is the benchmark, this is the best, and that will apply in our jurisdiction, I think needs to be taken with a pinch of salt. And every country needs to apply its own sort of principles. So legitimacy, credibility is not something that can be supplanted in your system. It needs to be created within the local context. And finally, my last point is about enforcement in the digital space. And I think world over the authorities are struggling and will continue to struggle. You know, did Microsoft pay its fine in the European Union? And I heard before that, you know, you fine companies, they delay, they go to courts, they get delays, they get legal barriers, they create, etc. All of that will continue to happen. Structural remedies are a problem. Behavioral remedies may or may not work. So I think the best enforcement tool, to my mind, I mean structural, is penalties and strong, swift and penal action which doesn't have recourse to the court system, which means if the CCI and the TRAI and the other courts can coordinate somehow, or the competition authorities and the sectoral authorities can coordinate somehow and say that, you know, this is it, this, we found evidence of abuse, and this is the fine, and this fine has to be paid, and if it is litigated, then it should be sort of termed as frivolous litigation. Action should be swift if there is evidence. Otherwise, in digital markets, you'll continue to get this. You reveal your source code, Microsoft says, I won't, I will, etc. It doesn't happen. Your choice or giving me the option of choice, it doesn't exist because I can't go to the next page of the app unless I click I agree, etc. Is it informed consent? All those issues, they are difficult issues to deal with. And companies, I think, given what I've said, given the narrative that I'm trying to create, which is that companies will habitually abuse monopoly power, litigation should be sort of not be allowed to be used as a gaming tactic, as a strategic tool, and action against companies who violated the law should be very swift, should be large, and should be carried out in coordination with other enforcement agencies. Otherwise, we are not going to see much sort of compliance by the digital companies. I think I've said enough. I'll stop here. Thank you.
Thank you, Prof, for those very insightful and thought-provoking ideas. And I think you came at the right time at the end of the session. And it's really for enforcers to think about these questions and whether it's a cat, and a mouse fight. I think we caught this mouse, but we don't want to kill it. It's a very tricky situation, right? So I think this is something that it's going to be at the forefront of discussions at the competition authorities. And your questions, I think you've identified very, very important questions. I know FS Russia had a digital cat at some point in time. I wonder how many mice it caught, but we will hear that some other time. So thank you very much. Let's give our panel a round of applause, and our apologies for taking the floor. Thank you.
Yeah, thank you, Honorable Chair and all the panelists. May I request you all to please step forward for a group photograph as we conclude this session, thanking each one of you for your very constructive and emphatic thoughts, and yes, if you can step forward, thoughts and also constructive suggestions and recommendations. Thank you. So we've slightly stepped over time, but then good discussions and thoughts expressed with some very constructive suggestions. And ladies and gentlemen, we are now going to be taking a short break, 15 minutes of tea and coffee break, and then please carry your belongings along with you, because this we are going to be splitting this hall in two as we start with our breakout sessions. Breakout session 1 is going to be on my left hand side, 2 goes on my right hand side. In BOS 1 we have competition analysis in digital economy, big technologies and algorithms, and in BOS 2 we are going to be discussing sustainability and climate change, new dimensions in competition law. So accordingly, as per your area of choice, you requested to kindly move in these 2 separate sessions, which we start after the tea break. Tea, ladies and gentlemen, stands again at the hard court where you had your lunch as well as your earlier tea. It's going to be a short tea break. Probably you can also carry your teacups and be back at your respective seats. I was told here. Pakka? Okay. Acha. Pakka. Okay. So, ladies and gentlemen, BOS 1 is going to be on my right hand side and BOS 2 is going to be on my left hand side. So, as I face the audience. BOS 1 is here. मुझे सुबह उल्टा बताया था.
2 members are not coming. वो BOS वाले.
एक बताया मुझे.
2.
तेजी बात है. जल्दी काम हो जाएगा. चाइना वाला तो हटा दिया.
दूसरे वाले में दोनों चाइनीज वाले
Please carry your belongings with you, for there's going to be slight dismantling of the entire place. We are going to be partitioning this hall. So BOS 1 happens on my right hand side, BOS 2 is going to be on my left hand side, and the sessions in BOS 1, what we are going to be deliberating is the competition analysis and digital economy, big technologies and algorithms, sustainability and climate change. We are going to be covering in BOS 2, which is going to be on my left hand side. Tea, ladies and gentlemen, is in the hard court area. You're requested to please join us for tea. And 3:50, though we intend to start, at the most we can just take it another 5 minutes, and then we are going to be good to be starting with our session. Thank you.